Welcome to Hilary Topper on Air, the podcast you can't afford to miss.
Losing a loved one is incredibly difficult. Emotions are high, and the last thing you want to do is go through your loved one's estate. Unfortunately, the probate process is something that oftentimes can't be avoided. So how can you make sure you're best prepared? I'm Hilary Topper, and this is Hilary Topper on Air. Today, I have the pleasure of speaking with Elena Puma, who is a partner of the Russo Law Group, Long Island's signature elder law, special needs, and estate planning law firm, or headquartered in Garden City. So, Elena, tell us a little bit about yourself and the Russo Law Group.
Well, thank you, Hilary, for having me on your show today. I appreciate it, and it's a pleasure to be here. As you said, my name is Elena Puma, and I'm a partner at the Russo Law Group. I have been at the firm for just under 30 years, which is a very long time.
Awesome.
And it's been a wonderful experience because it provides an opportunity to help so many families and individuals, and that is what I wanted to do when I selected becoming an attorney as my profession. So as you said, we are an elder law, estate planning, special needs, trust and estate administration law firm, and we like to think of ourselves as problem solvers. We create and cultivate relationships with our clients and their families, and we want to help them. We want to take the journey with them and walk along the way and help them as they, as they address problems, and whatever support we can provide to them, we like to do. And if we can't help them, we provide them with the resources to do so.
That's awesome. So today's topic is probate, or the probate process. Can you tell us what a probate proceeding is?
Sure. So a probate proceeding is the legal process of submitting a person's last will and testament who passed away to the surrogate's court. So the surrogate's court has to review the will to make sure that it's properly executed and that it's a valid will. And then when the surrogate approves of that will, the surrogate will appoint the executor who's nominated under that will to be the fiduciary, the person who is now authorized to handle the decedent's affairs.
So when is a probate proceeding required?
Okay, so once the court appoints the executor, the court will issue a legal document to the executor known as letters testamentary. And that is a certificate that will show their authorization to then go out and deal with the financial institutions and whatever they need to address for the decedent. So the need for that occurs when you need a probate proceeding. So a probate proceeding is required when you have quote-unquote probate assets. So just to take a step back, a person's gross estate is comprised of two types of assets in very broad categories: probate assets and non-probate assets. So probate assets are assets that were just owned by the individual who passed away, who I will call the decedent, in the decedent's name alone. So, for example, a piece of real property in the name of John Smith, a bank account in the name of John Smith. There's no other name of any person in that title of the asset. So because it was solely in that decedent's name alone, you have to go to court to get the will probated, to get the executor appointed so that somebody can be appointed to access that asset. The other type of assets are what's called non-probate assets. Again, a broad category. Non-probate assets are assets that the decedent owned, but somehow in the title of the asset, the decedent said what should happen upon his or her death to make that asset pass by operation of law outside of the probate process. And examples of those types of assets, and there are many, are, for example, an IRA designating a beneficiary, a life insurance policy or an annuity designating a beneficiary, a bank account owned as joint tenants with rights of survivorship, real property owned by husband and wife in a way that only they can do, tenants by the entirety, brokerage accounts that are owned TOD, transfer on death, bank accounts owned ITF, in trust for savings bonds, for example, owned POD, payable on death, or even living trusts. So there are many ways that you can own assets and allow them to pass outside of the probate process upon death. And those are just some of the examples.
Interesting. So talk to me a little bit about an executor or an administrator. What's the process for an executor or an administrator to be appointed? And what happens if the executor passes away before the person who passes away? Yeah.
Very, very, very good question. So let me just explain the difference for your listeners between what an executor and administrator. They're both appointed by the surrogate's court for the in the county in which the decedent was domiciled, because that is where the proceeding is commenced. So the difference is the executor is actually somebody nominated in the decedent's will. Okay, so the decedent had a last will and testament and said, I want to nominate my spouse as my executor. An administrator is when a person dies intestate, meaning they did not have, he or she did not have a will. So because they don't have a will that said, the will says, I want so-and-so to be my executor and this is how I want my assets to pass. When you don't have a will, it's intestacy proceeding, which now the court appoints an administrator who is just like an executor, but it's an administrator because there's no will, and the administrator distributes the assets in accordance with the laws of intestacy. And New York state laws state in an order of priority who can be that administrator and who will inherit based upon those laws. So that's the difference. Now, the process then when you petition the surrogate's court is very similar. It's just that it's called a different proceeding. It's a probate proceeding versus an administration proceeding. And in both proceedings, you need to petition the court. You need to obtain waivers and consents from the closest living blood relatives, so that they have an opportunity to contest the will or to know that they're being provided for under the laws of intestacy. And there are a whole bunch of other ancillary documents to the process. And then ultimately, the surrogate's court will appoint a fiduciary. If it's an executor, they receive letters testamentary, which I referenced before. And if it's an administrator, they receive letters of administration. Either way, those documents are valid for them to handle the decedent's affairs. Now, you did ask me another part to that question, which was, what happens should the executor predecease the person, the testator, say, under the will? Well, usually there's a provision in the will that says, I appoint Jane Smith, my spouse, as my executor, and if she is unavailable, unable, unwilling to serve, etc., then I appoint a successor executor, Paul Smith. So you usually have successors in the document in case that occurs. In the situation of intestacy without a will, like I said earlier, there's an order of priority. So the court will say, the first it's the spouse, then it's the children, and so forth.
Interesting. All right, before we move on, I just want to take a minute out and thank our sponsors. Please support our sponsors and tell them that you heard about them on Hilary Topper on Air. Special thanks to the Russo Law Group, MedPro, Strain Print, and Fortunoff Fine Jewelry. Now back to you, Maria Elena. How can you avoid a probate proceeding?
Okay, so it's, a lot of times people want to avoid probate, and sometimes it's a good thing, and sometimes it may necessarily be a bad thing. Just because you have a probate doesn't always mean that it's problematic. So there's a common misconception out there that probate is bad, but there are certain instances when probate is good. So I just want to put that out there. But if your goal is to avoid probate, then when you're planning, you have to make sure that you title all of your assets properly so that they will pass as quote-unquote non-probate assets by operation of law upon your death. And So you have to make sure that if you have an IRA, that you have a beneficiary designated and that you have a contingent beneficiary designated in the event that that person predeceases, the person who's doing the planning. You make sure that your bank accounts and your brokerage accounts have a joint tenant or are transfer on death to somebody. So you make sure your real property is owned jointly with somebody with right of survivorship or tenants by entirety with a spouse. So you have to make sure that you properly designate the title on your assets. You could also establish a trust. There are many types of living trust, revocable, irrevocable. And you can transfer your assets into those trusts. And I say that because it's very important. That trust is only as good as you're taking your assets and transferring them and retitling them into the trust. I can't tell you how many times I meet with families who say, oh, sure, my parents had a trust and we don't think we need a probate, and obviously it's not a trust that we prepared. And when I sit down and I look, I see that the parents never funded the trust. So the assets, they have this beautiful trust to avoid probate, but the assets are still in their names alone. So it's very important that you do this properly, and if you have a trust, that you fund it. So we always recommend that, estate planning is a fluid transaction. It's not just a single transaction. So we want our clients to come in and meet with us annually so that we can review their assets, to take a look at, do they have a new bank account? Sometimes they have a CD that renewed, and now, let's check the title on that. If your goal is to avoid probate, let's make sure you funded your trust properly. So it's important that you just don't do this once as a single transaction. And that's why we create relationships with our client, and we meet with them periodically so that we can see if anything changed in their lives that will impact their plan.
So at what age do you do this?
Well, we believe it's never too soon to start planning because, we don't have a crystal ball, and life always throws us curveballs, and we don't know what to expect. So it's always a good thing to get your affairs in order, and we, a lot of times our clients don't realize until because what we usually do is we send them some information before they come in and with a brief questionnaire just to get them thinking about what their assets are. And when they come in, they're really surprised because they didn't realize that they had so many assets or the value of their assets when you actually put pen to paper.
Right.
So, it's never too soon to get your house in order, so to speak, and to get a sense of what you have. Take a look at the ownerships and the titles on those assets, and to think about what your dispositive plan, would be. So I would say as soon as you start having assets, you should start to think about that.
Yeah, no, that's great advice. I mean, my other question to you was, you had alluded to titling things properly, and I'm wondering, is it really smart for somebody to do this without a lawyer?
I think it's always wise to consult with an attorney to at least give you the advice and direction on how to, what would work great in your plan, and then you can work with the institutions to make sure that you complete whatever documents that they require. What we then do is we ask our clients to send us a copy of that statement so that we can see that it actually occurred. Send us a copy of that IRA beneficiary designation so that we now have a record of it and we see that it was done properly. So I think sometimes the clients want us in the middle. We're at the beginning where we say, hey, this is what we think you should do. And at the end, we say, prove it to us, show us in writing what was done. And the clients handle it themselves in the middle, which is the actual transactions. But then there are some clients who, they like to have their hands held, and it's our pleasure to do so, and we assist them with those transactions.
So can you offer us an example or a case study of any recent clients who you've helped?
Oh, sure. I'm pleased to say that there have been many different situations, and I'm just trying to think of one that might be interesting to your listeners. I had recently I guess this would be a good one, a situation where the decedent passed away. He was the second to die. His wife had died previously, and they had about 6 children. I think it was 6. And they he was the last to die, but over the years, different situations occurred with the children. So he wanted to make sure that, in other words, he was not going to treat all the children equally. So he wanted to avoid probate for that reason, and he was making sure that he had certain accounts that provided for other children, and so forth, so that they each would get an even out or whatever it was. There was one asset that he had transferred. Well, there were 2 assets that he had transferred on his own to avoid probate, and for some reason the form was not completed correctly. And then the institution never notified him, and then he passed away. So what happened was there ended up being a probate, and the one child that wasn't being, well, 1 or 2 children that weren't being treated the same as the others had now an opportunity to, contest.
Wow.
So, we were able to work everything out, which was a good thing. But the bottom line is we had a will that was properly executed, that was witnessed, that was notarized. So it wasn't an issue. It wasn't something that was subject to attack. So it was very good that the plan was put into place. But, that's a very complicated proceeding. And then there are other cases where, you have a probate because it was a husband and wife, and now they're both deceased, and you have 2 children, and they have a house to sell. And it's a very simple transaction. So probate could be complicated because it gives an opportunity for somebody to contest who may not be treated the same way. But on the other hand, probate can be very simple in terms of passing property to children. And also, probate can be good because sometimes you have a beneficiary who has special needs, who may be receiving government benefits. And avoiding probate, say, for example, with a bank account in trust for that person would be hugely problematic because they would lose their government benefit if they received it outright. So in that case, a probate is very important because the will would say if my beneficiary is receiving any kind of government benefits and this asset that I'm leaving to him or her would adversely affect their eligibility, then I put this into what is known as a testamentary supplemental needs trust, which will be there for my child's benefit, but will not adversely impact his or her benefits. So in that case, you want a probate because you want to set up that trust, and you would not want an asset to pass by operation of law in that situation.
Wow, that's really interesting. So tell us how people, our listeners, can get in touch with you to learn more about the Russo Law Group.
Well, we love to be a resource to the community. So you can, your listeners can go onto our website at vjrussolaw.com. They can call us at our office, 516-683-1717, and ask to speak with one of our coordinators, and if if they have any questions, we might be able to get them in for an appointment or speak with an attorney to see if it's something that we can help them with. We are a resource. We also do consumer seminars, so we're out in the community. We have a calendar on our website that tells everybody when those programs are being offered, so feel free to register and join us.
It's awesome. Such an interesting interview. Thank you so much, Maria Elena, for being on the show. Today's topic was probate and the probate process. So I appreciate that, and thank you for walking us through that. I also want to thank our sponsors, the Russo Law Group, MedPro, Strain Print, and Fortunoff Fine Jewelry. And last but not least, I want to thank you, our listeners, for tuning in. If you want more information on this show or any other show, visit our website at hilarytopperonair.com, or you can find us on Spotify, iTunes, Google Play, SoundCloud, Mixcloud, you name it, we're out there. Have a great week, and we'll see you next time.